As the rationales for the court's coerced confession cases evolved, it became increasingly doubtful that terms such as voluntariness, coercion, and breaking the will were very helpful in deciding the admissibility of confessions. It appeared that such terms were not being used as tools of analysis, but as mere conclusions when a court concluded that the police had resorted to unacceptable interrogation techniques. It called the resulting confession involuntary. On the other hand, it seemed when a court decided the methods the police had employed were permissible or tolerable, it called the resulting confession voluntary. Moreover, such terms as voluntariness, coercion, and overbearing the will focused directly on neither of the two underlying reasons that led the courts to bar the use of confessions: the offensiveness of police interrogation methods, or the risk that these methods had produced an untrue confession. Thus, as the court per O'Connor recently noted in Miller v. Fenton, the voluntariness rubric has been variously condemned as useless, perplexing, and legal double talk. Almost everything was relevant under the due process. Totality of the circumstances, voluntariness test, example, the suspect's age, intelligence, education, prior criminal record, whether he was advised of his rights, held incommunicado, or given meals at regular intervals, but with very few exceptions. Example, the use or threatened use of physical violence. No single factor was decisive. Because there are so many variables in the voluntariness equation that one determination seldom served as a useful precedent for another, the test offered neither the police nor the courts much guidance. Trial courts were most invited to give weight to the subjective preferences, and appellate courts were discouraged from active review. Understanding, some members of the court looked for an alternative approach. In the 1959 Crooker case, discussed below, the four dissenters turned to the right to counsel. 5 years later, as illustrated by the two cases in this section, Massiah versus United States and Escobedo versus Illinois, the right to counsel approach to confessions had gained ascendancy. So the rubric of voluntariness test has too many variables. So there was then a connection to right to counsel. Okay, Crooker versus California, 1958, involved a petitioner who had attended 1 year of law school, during which time he studied criminal law, and who indicated that he was fully aware of his right to remain silent. On the basis of a challenged confession, he was convicted in the murder of his paramour and sentenced to death. A 5-4 majority rejected his argument that by persisting in interrogating him after denying his specific request to contact his lawyer, the police had violated his due process right to legal representation and advice, and that therefore the use of any confession obtained from him under these circumstances should be barred, even though voluntarily made under traditional standards. Such a rule, retorted the court per Clark, would have a devastating effect on enforcement of criminal law, for it would effectively preclude police questioning, fair as well as unfair, until the accused was afforded opportunity to call his lawyer. Due process demands no such rule. But for dissenting justices, Douglas, joined by Warren, Black, and Brennan, maintained that the demands of our civilization expressed in the Due Process Clause require that the accused who wants a counsel should have one at the time after the moment of arrest. The following year, by virtue of Spano v. New York, it appeared that a majority of the court had arrived at the view that once a person is formally charged by indictment or information, her constitutional right to counsel has begun. At least. So in Croker, California, it would be an obstruction to fair as well as unfair interrogation. But by the time we got to Spano, it seems like the majority wants it to be a right. The right to counsel has begun, at least the right to assistance of counsel. She herself has retained. 4 concurring justices took this position in Spano, Justices Black, Douglas, and Brennan, all of whom dissented in Croker, and newly appointed Justice Stewart, who had replaced Justice Burden. In 2 separate opinions, the concurring justices emphasized that Spano was not a case where the police were questioning a suspect in the course of investigating an unsolved crime, but where the person interrogated was already under indictment for murder when he surrendered to the authorities. This is an important distinction. Right? It's not investigatory. It's after indictment. The majority in the Spano court did not decide the case on the grounds suggested by the concurring justices because it found the inadmissible under the traditional due process voluntariness test. But the Chief Justice Warren, who wrote the majority opinion, had taken the position a year earlier in Croker that the right to counsel should begin even earlier than at the point of indictment. Thus, counting heads, it appeared that by 1959, the views of the concurring justices in Spano commanded a majority of the court. Any doubts were dispelled by Massiah versus United States, the first case in this section. When, a short 5 weeks after it had decided Massiah, the court threw out the confession of Escobedo versus Illinois, the second case in this action. Even though Escobedo had been interrogated before judicial or adversarial proceedings had commenced against him, many members of the bench and bar grew alarmed as they saw it. The right to counsel approach to the confession problem threatened the admissibility of even volunteered statements. They feared that the court might be in the process of shaping a novel right not to confess except knowingly and with the tactical assistance of counsel. Sometimes the enthusiastic public reaction to the Gideon decision a year earlier had led some members of the court to believe that Massiah and Escobedo would also be well received, but many members of the bench and bar, and the general public as well, soon left little doubt that they were much more enthusiastic about a lawyer for a defendant in the courtroom than they were about a lawyer for a suspect at this police station. So, starting with Massiah versus United States. 1964, Justice Stewart delivered the opinion of the court. After he had been indicted for conspiracy to possess narcotics aboard a United States vessel and other federal narcotics violations, Massiah retained a lawyer, pled not guilty, and was released on bail. Colson, a co-defendant, also retained a lawyer, pled not guilty, and was released on bail. Colson then invited Massiah to discuss the pending case in Colson's car, parked on the city street. Unknown to Massiah, Colson had decided to cooperate with federal agents in their continuing investigation of the case. The radio transmitter was installed under the front seat of Colson's car, enabling a federal agent, Murphy, who had equipped with a recording device to overhear Massiah-Colson conversation. As expected, Massiah made several damaging admissions. On the basis of these admissions, Massiah was convicted of several narcotics offenses. The convictions were affirmed by the U.S. Court of Appeals for the Second Circuit. In Spano v. New York, the court reverses state criminal conviction because the confession had been wrongly admitted into evidence against the defendant at his trial. And I keep losing my spot. At his trial. In that case, the defendant had already been indicted for first-degree murder at the time he confessed. The court held that the defendant's conviction could not stand under the 14th Amendment, while the court's opinion relied upon the totality of the circumstances under which the confession had been obtained. And this is case law. Come on, Erica. Totality of the circumstances under which the confession had been obtained. Four concurring justices pointed out that the Constitution required reversal of the conviction upon the sole and specific ground that the confession had been deliberately elicited by the police officer and the defendant had been indicted, and therefore at a time when he was clearly entitled to a lawyer's help. It was pointed out that under our law contemplate that an indictment be followed by a trial in an orderly courtroom presided over by a judge, open to the public, and protected by all the procedural safeguards of the law. It was said that a constitution which guarantees a defendant an aid of counsel at such a trial should surely vouchsafe no less to an indicted defendant under interrogation by the police in a completely extrajudicial proceeding. Anything less, it was said, might deny a defendant effective representation by counsel at the only stage when legal aid and advice would help him. The view taken by Spano concurring justices no more than reflects a constitutional principle established as long as the period of the proceedings, that is to say, from the time of their arraignment until the beginning of their trial, when consultation, thoroughgoing investigation, and preparation are vitally important. The defendants are as much entitled to such aid of counsel during the period as at the trial itself. Here we deal not with the state court conviction, but with the federal case where the specific guarantee of the Sixth Amendment directly applies. We hold that the petitioner was denied the basic protections of that guarantee when there was used against him at his trial evidence of his own discriminating words, which federal agents had deliberately elicited from him after he had been indicted, and in the absence of his counsel. It is true that in the Spano case, the defendant was interrogated in a police station where the damaging testimony was elicited from the defendant without his knowledge while he was free on bail. Hayes points out in his dissent in the Court of Appeals, if such a rule is to have the efficacy, it must apply to indirect as well as those conducted in the jailhouse. In this case, Massiah was more seriously imposed upon because he did not even know that he was under interrogation by the Solicitor General. The Solicitor General has strenuously contended that strenuously contended that the federal law enforcement agent had the right, if not indeed the duty, to continue their investigation of the petitioner and his alleged criminal associations, even though the petitioner had been indicted. He says that the quantity of narcotics involved was such as to suggest that the petitioner was part of a large and well-organized ring, and indeed that the continuing investigation confirmed the evidence. Under these circumstances, the Solicitor General concludes that the government agents were completely justified as having Colson continue his. We do not question that in this case, as in many cases, it was entirely proper to continue an investigation of the suspected criminal activities of the defendant and his not incredibly long, it's just 3 of them cited here. It is a rather portentous occasion when the constitutional rule is established barring the use of evidence which is relevant, reliable, and highly probative of the issue which the trial court has before it. Whether the accused committed the act with which he is charged without the evidence, the quest for truth may be seriously impeded. In many cases, the trial court, although aware of proof showing defendant's guilt, must nevertheless release him because the crucial evidence is inadmissible. The result is entirely justified in some circumstances because exclusion serves other policies of overriding importance, as where evidence seized in the legal search is excluded, not because of the quality of the proof, but to mere emphasizes that the sound of evidence otherwise admissible in the creation of another area of privileged testimony. With all due deference, I am not at all convinced that the additional barriers to the pursuit of truth which the court today erects rests on anything. The importance of the matter should not be underestimated, for today's rule promises to have wide application well beyond the facts of this case. The reason given for the result here, the admissions were obtained in the absence of counsel, would seem equally pertinent to statements obtained at any time after the right to counsel attaches, whether there has been an indictment or not. To admissions made prior to arraignment, at least where the defendant has counsel or asks for it, to criminal proceedings in the courts, and to defendants the new rule will immediately do service in a great many cases. Whatever the content or scope of the rule may prove to be, I am unable to see how this case presents a constitutional interference with Massiah's right to counsel. Massiah was not prevented from consulting with counsel as often as he wished. No meetings with counsel were disturbed or spied upon. Preparation for trial was in no way obstructed. It is only a sterile syllogism, an unsound one besides, to say that Massiah had a right to counsel's aid before and during the trial. His out-of-court conversations and admissions must be excluded if obtained without counsel consent or presence. The right to counsel has never meant as much before as its extension in this case requires some further explanation so far unarticulated by the court. Since the new rule would exclude all admissions made to the police, no matter how voluntary and reliable, the requirement of counsel's presence or approval would seem to rest upon the probability that counsel would close any admissions at all. This is nothing more than a thinly disguised constitutional policy of minimizing or entirely prohibiting the use of evidence of voluntary out-of-court admissions and confessions made by the accused, carried as far as blind logic may compel some to go. Notion that statements from the mouth of the viewed in this light, the court's newly fashioned exclusionary principle goes far beyond the constitutional privilege against self-incrimination, which neither requires nor suggests the barring of voluntary. Whether as a matter of self-incrimination or due process, the proscription is against compulsion, coerced incrimination under the prior law announced in countless cases in this court. The defendant's pretrial statements were admissible evidence if voluntarily made, inadmissible if not the product of his free will. Hardly any constitutional area has been more carefully patrolled by the court And until now, the court has expressly rejected the argument that admissions here to be deemed involuntary if made outside the presence of counsel. The court presents no facts, no objective evidence, no reasons for warrant scrapping the involuntary test for admissibility in this area. Without such evidence, I would retain in its present form. This case cannot be analogized to the American Bar Association's rule forbidding an attorney to talk to the opposing party litigant outside the presence of his counsel. Constitutional dimensions. Okay. So it's not really ex parte, is what they're trying to say. The specific canon argued is inopposite because it deals with the conduct of lawyers and not with the conduct of investigators. Lawyers are forbidden to interview the opposing party because of the supposed imbalance of legal skill acumen between the lawyer and the party litigant. The reason for the rule does not apply to non-lawyers and certainly not to Colson, Massiah's co-defendant. Applying the new exclusionary rule is peculiarly, however, for co-defendants represented by the same counsel, Colson shouldn't be working with the federal government unbeknownst to counsel and co-defendant. So I'm not sure if that was in the facts. But co-defendant kind of gives me the impression maybe they do have the same lawyer, but I don't know. In this case, at the time of the conversation in question, petitioner was not in custody but free on bail. He was not questioned in what anyone would call an atmosphere of official coercion. That he was said to his partner in crime, who had also been indicted. There was no suggestion or any possibility of coercion. That petitioner did not know readily admissible at the trial, as would a recording which he might have made of the conversation occurred. He had been operating when the recorded conversations are somehow transformed into an inadmissible evidence, despite the fact that the has precisely the same. This is a fact we challenge to evidence on acquired after constitutionally immunize their statements made in furtherance of these operations and relevant to the question of their guilt at the pending prosecution. Undoubtedly, the evidence excluded in this case would not have been available but for the conduct of Colson in operation with Agent Murphy. But is it this kind of conduct which should be forbidden to those charged with law enforcement? It is one thing to establish safeguards against procedures fraught with the potentiality of coercion and substitute for brains as an instrument of crime detection. But here there was no substitution for brutality, no inherent danger of police coercion justifying the prophylactic effect of another exclusionary rule. Massiah was not being interrogated in a police station, was not surrounded by numerous officers or questions and relays, and was not forbidden access to others. Law enforcement may have the elements of a contest about it, but it's not a game. Massiah and those like him received ample protection from the long line of precedents in this court holding that confessions may not be introduced unless they are voluntary. In making these determinations, the court must consider the absence of counsel as one of several primary factors of which voluntariness is to be judged. This is a wiser rule than the automatic rule announced by the court, which requires courts and juries to disregard voluntary admissions, which they might well find to be best possible evidence in discharging their responsibility for ascertaining truth. Gonna take a break before we get into Escobedo versus Illinois on page 415. Goldberg gives that opinion, and then there's three more I've just